Even after the criminal trial ends, this story may not be over, because in cases like this, the verdict is only the beginning of a second, quieter legal battle, one that can take longer, cost more, and ultimately decide what happens to everything. So, how long can this process actually last? And what does the law look at when deciding who deserves to inherit? How long these cases really take. In high-profile cases involving major estates, multiple heirs, and unresolved legal questions, probate alone can last anywhere from 2 to 10 years. That timeline depends on whether the criminal case goes to trial, whether there are appeals, whether there are disputes between heirs, whether the estate includes complex assets like businesses, intellectual property, or ongoing royalties. During that time, the estate is typically managed by court-appointed administrators. Their job is to preserve the value of the assets, not to distribute them. That means investments may continue, royalties may still be collected, properties may still be maintained, but no one truly owns anything yet. The estate exists in a legal waiting room. What probate judges actually look at probate courts do not simply check whether someone was convicted. They look at a wider set of factors, including the wording of the will, if one exists, the intent of the deceased, if it can be established, the findings of the criminal court, whether inheritance would contradict public policy, and whether allowing inheritance would undermine the purpose of the law. In other words, probate judges are not only interpreting rules, they are interpreting intent. That is why two similar cases can sometimes have different outcomes. Why public opinion does not decide anything. High-profile cases often generate intense public reaction, but courts are specifically designed to operate independently from that reaction. Judges are trained to rely on evidence, legal standards, and precedent, not on headlines, social media, or emotional pressure. That separation is intentional. It protects both the rights of the accused and the integrity of the legal process. And in cases like this, that separation is what allows the system to function at all. The role of the will. Another critical factor is whether Rob and Michelle Reiner left behind a will and what it says. If a will exists, it may specify how assets should be divided, include conditional clauses, establish trusts, or limit access to certain heirs. However, even a will cannot override the Slayer rule if it applies. And even a will can be contested in probate court. So the will is important, but it is not necessarily final. The impact on the other heirs. There are other surviving children. Their legal position is separate from Nick Reiner's. If Nick is legally blocked from inheriting, the estate may be redistributed among the remaining heirs, or handled according to the will. This can lead to disputes, negotiations, or settlements. In many cases, families choose to settle privately rather than engage in years of litigation. But in high-profile estates, private resolution is not always possible. Why lawyers call this a perfect storm. Legal experts sometimes describe cases like this as a perfect storm because they combine criminal law, inheritance law, family law, media attention, and public emotion. Each of those elements moves at a different speed. Each has different rules, and none of them can be rushed. That is why no one involved can give a simple timeline or a simple answer. The system is designed to move carefully, not quickly. So while the headlines focus on the criminal charges, the future of the Reiner estate will be shaped by a slower, quieter, and far more technical legal process. A process that may last for years. A process that may involve multiple courts. And a process whose outcome remains completely uncertain. In the next part, we'll look at similar past cases, what eventually happened in those situations, and what patterns they might reveal about how this case could ultimately be resolved. What makes this situation even more complex is that inheritance law is not designed for emotional clarity. It is designed for procedural fairness. That means every step must be documented, argued, reviewed, and approved. And that takes time. In similar high-profile inheritance cases, probate courts have taken several years just to resolve basic questions like who qualifies as an heir, what assets belong to the estate, and which legal rules apply. Only after those questions are resolved does the court begin to address distribution. So when people ask, who gets the money? The most accurate answer is often, not yet. In the meantime, the estate itself does not remain frozen in place. It is actively managed. Court-appointed administrators oversee investments, property, royalties, and business interests. Their job is not to grow the estate aggressively and not to dismantle it. Their job is to preserve it. That means keeping companies running, maintaining properties, collecting revenue, and paying taxes and expenses. So while no one may be inheriting yet, the financial engine continues to operate quietly in the background. Another layer of complexity comes from how large estates are structured. Many wealthy individuals do not hold their assets in one simple account. They use trusts, holding companies, licensing entities, and long-term financial vehicles. Each of those has its own legal rules. Each may require separate court approval, and each can become its own point of dispute. That means the estate is not one legal object. It is a network of legal objects, and each one must be processed carefully. This is one of the reasons why legal experts rarely give firm predictions in cases like this. There are too many moving parts, too many unknowns, and too many possible legal arguments. Even small procedural decisions can change the timeline by months or years. There is also the question of appeals. If the criminal case ends in a conviction or acquittal, that decision may still be appealed. Appeals can take years, and during that time, probate courts often pause final decisions, so the legal uncertainty can extend far beyond the initial trial. This creates a situation where the public story moves fast, but the legal story moves slowly. Headlines change weekly, courtrooms change yearly, and estates change over decades. That mismatch in time is one of the main reasons cases like this feel unresolved for so long. At the center of all this is a system trying to do something very difficult. It is trying to treat a deeply emotional situation as a procedural one. It is trying to separate grief from legality. And it is trying to protect both the rights of the deceased and the rights of the living. That is not a system designed for satisfaction. It is a system designed for stability. And that is why, even now, no one can honestly say what the final outcome will be. Not the media, not the public, and not even the lawyers. Because the answer does not exist yet. It will only exist after years of decisions, documents, hearings, and rulings. One step at a time. Another factor that often goes unnoticed in stories like this is the role of private settlements. Not every dispute inside probate court ends with a public ruling. In many high-value estates, the parties eventually reach private agreements. These agreements can divide assets quietly, avoid years of litigation, reduce legal costs, and keep sensitive family matters out of the public record. But private settlements require cooperation. And cooperation is not guaranteed in situations involving grief, money, and legal uncertainty. If the heirs disagree on terms, the court remains the only option. And court processes, by design, are slow. There is also the question of reputation. High-profile cases create long-term reputational effects for everyone involved. Business partners, licensing companies, studios, and financial institutions all watch these cases closely. Not because of gossip, but because legal uncertainty creates financial risk. As long as the estate remains unresolved, companies may delay contracts, payments, or long-term commitments. That means the legal process does not only affect the family, it affects an entire business ecosystem connected to the estate. This is one of the reasons why courts take such a cautious approach. A single ruling can have ripple effects across multiple industries. So judges move carefully. They review precedent, they consider policy, and they aim for decisions that will hold up under appeal. There is also a broader legal principle at play. Inheritance law is not just about distributing assets. It is about expressing societal values. It reflects ideas about fairness, responsibility, and moral boundaries. The Slayer rule exists not to punish, but to prevent the legal system from appearing to reward harmful behavior. At the same time, due process exists to prevent the system from punishing without proof. So these two principles are in constant tension. And cases like this are where that tension becomes visible. From the outside, it can feel frustrating. People want closure, they want a clear answer, they want a resolution. But the legal system is not built to satisfy emotional timelines. It is built to survive scrutiny, and that means it prioritizes correctness over speed. Over time, attention fades. Media moves on, public interest shifts, but the legal process continues, quietly, methodically, and often unnoticed. So when this story eventually ends, whether that is in court, in a settlement, or in a final ruling, it will not arrive as a dramatic moment. It will arrive as a document, a filing, a signature, a judgment entered into a system. And life will continue. One of the most difficult parts of this entire process is that the legal system does not offer emotional resolution. It offers procedural resolution. That difference matters, because for families involved, no ruling can restore what was lost, no judgment can fully settle grief, and no financial outcome can replace personal relationships. The law can only decide what happens next, not what happened before. This is why statements from families in situations like this often sound similar. They ask for privacy. They ask for compassion. They ask for restraint, not because they want to avoid scrutiny, but because the process itself is already heavy. Public attention adds another layer of pressure. From the court's perspective, this is also why public commentary has no legal weight. Judges are insulated from opinion for a reason. It protects both the integrity of the outcome and the legitimacy of the system. If rulings were influenced by popularity or outrage, the system would lose credibility. Another overlooked detail is how estate taxes and obligations are handled during long probate processes. Taxes still apply, expenses still accumulate, legal fees still grow. That means the longer a case lasts, the smaller the final estate may become, not because of wrongdoing, but because time itself has a cost. This is another incentive for parties to reach agreements when possible. But again, agreement requires trust. And trust is often the first casualty in situations involving legal conflict. Over years, the legal narrative becomes technical. It becomes about filings, motions, hearings, and deadlines. The human story fades into the background. What remains is structure, process, procedure. And yet, this is exactly how the system is supposed to work. Not because it is cold, but because it must be stable. It must treat every case, emotional or not, with the same standards. That is what protects people when they are accused, and what protects victims when wrongdoing is proven. So, while this story began with shock and headlines, it will likely end with paperwork. That may feel unsatisfying, but it is the price of a system that values consistency over drama. There is also a final layer that rarely gets discussed in public, and that is the long-term impact on how families structure their estates in the future. High-profile legal disputes often change how other people plan their own affairs. They encourage the use of trusts. They encourage clearer wills. They encourage legal planning that anticipates conflict, not harmony. So even cases like this, while deeply personal, can shape broader legal behavior. They become reference points, not because people want to repeat them, but because they want to avoid them. Legal professionals study these cases closely, not for spectacle, but for precedent, for patterns, for guidance. They ask, what arguments succeeded? What arguments failed? Which interpretations held up on appeal? Those answers quietly influence thousands of future legal decisions. In that sense, the story is larger than any one family. It becomes part of a legal memory, a data point, a lesson embedded in case law. And that is how legal systems evolve, not through sudden changes, but through slow accumulation of decisions. Eventually, the case will conclude. There will be a final distribution, or a settlement, or a ruling that closes the file. And the world will move on, not with a moment of resolution, but with a gradual fading of attention. But for the people involved, the impact will remain, not as headlines, but as lived experience, as memory, as something private again. And that is perhaps the most important thing to remember. Behind every legal case is a human story, And behind every legal rule is an attempt to manage human complexity fairly, not perfectly, but consistently. And that consistency is what allows the system to function across generations. Long after individual cases are forgotten, the rules remain. They become part of a framework that shapes how future conflicts are handled, quietly, systematically, without drama. That is why legal outcomes often feel anticlimactic, not because they lack importance, but because they are designed to close questions, not create narratives. In the end, what remains is not the case itself, but what the case leaves behind: a clarified rule, a reinforced principle, a reminder of how the system responds when law and human emotion collide. That is the real legacy of cases like this. Not the money, not the headlines, but the structure they leave in place. For the public, this story may fade into memory. For the courts, it becomes a reference. For legal professionals, it becomes a lesson. And for families watching from a distance, it becomes a reason to plan more carefully, to write clearer wills, to build stronger structures, to anticipate not only harmony, but disagreement. That shift, from assumption to preparation, is one of the quiet ways law changes behavior. People do not change because they are forced to. They change because they observe consequences. And they adapt. So while this case may one day be archived, cited, and closed, its influence may continue. Not loudly, not visibly, but steadily. Through documents, through contracts, through decisions made in private offices, years from now, by people who never knew the names involved. And that is how legal systems actually evolve. Not through moments, but through accumulation. One case at a time, one decision at a time, one adjustment at a time. Which is why the most accurate way to understand stories like this is not as events, but as processes: slow, imperfect, human, and ongoing. Because the law is not a machine that delivers closure. It is a framework that manages uncertainty. And sometimes the only honest ending a story like this can have is not an answer, but time. So the real question isn't what happens next in this case. The real question is what this kind of case tells us about how the system actually works. Because when law, money, and family collide, the outcome is rarely simple, and almost never fast. So, what do you think? Should inheritance law be purely procedural, or should it also reflect moral responsibility? Should someone ever be allowed to inherit from a situation tied to harm, even if the law technically allows it? And should courts prioritize strict rules or human context? There's no single right answer. But the way we answer those questions shapes how these cases are decided in the future. Let me know what you think in the comments. In the next video, we'll continue this story and look at what similar past cases can teach us about how this might eventually be resolved.